Hey, good morning if you're watching this in the morning, and good afternoon if you happen to be watching this in the afternoon. My name is Christopher Koos. I'm the Operations Division Manager here in Atlantic County, and today we're here to talk about subpoenas. So do we want documents, testimony, or post-judgment information? Those are the questions you should be asking yourself when thinking about a subpoena. So we have three kinds of subpoenas in New Jersey. We have subpoena ad testificandum, which is when you want somebody to come into court and actually testify. I like to think about this as you're adding testimony. So it's subpoena ad testificandum. You're going to add testimony to your case, so you would send that subpoena. The second type of subpoena we have in New Jersey is a subpoena duces tecum. That is a subpoena for the production of evidence which requires the witness to produce documents, records, or other tangible objects for examination at a trial or hearing. In this one, I like to think about the tecum part. So when you need documents, you're going to take them. So it's the subpoena duces tecum, and that would be served on a party, and you would tell them, hey, bring me your documents. The third type of subpoena we have, and a little less common, I think, is the informational subpoena. This is a legal document signed by the court clerk that orders the debtor or others to answer questions about where their assets are located. So we're actually going to talk about that one first. So I have a copy of one here. So it is an information subpoena. I think one of the more important things to do whenever you have kind of anything with the court is to know where to find those documents. I like to go to Google. So on this, I did a search right before coming out here to make sure it's good. You would go to google.com. If you typed in New Jersey Superior Court Information Subpoena, the #1 result would be information subpoena and written questions, which is what I'm holding right here in front of me. If you can see it, if you're watching the video. If you only have the testimony, just take my word for it. I was holding up the document. So here, what you're going to do is, if you go to court, so let's say you had a small claims case or a special civil part case, and you win a judgment, you're going to want your money, but you're not going to know where it is. In New Jersey, we have, as I said before, an information subpoena. You can actually fill that out. You'd put in your information, the name of the case, the docket number, and things like that. You can serve that on the defendant, and they would have to, by law, provide you with answers. Now, I won't go through the whole document here, but I'll just read a few of the questions to give you an idea of what you can ask for. So it's going to ask for their birth date, their social security number, their driver's license number, if they have a wage execution, if they're employed, where are they employed, where do they bank? You can ask if they own a car, if they have assets, if they have loans. And this form, like I said, it's on Google, and New Jersey Information Subpoena is already filled out for you as far as the questions go. All you have to do is add the case information, and you can then serve that on the defendant. Next, we're going to talk about the subpoena duces tecum. If you remember, that's where we're going to take those documents. So I want to start out with telling you where to find this form. And it actually will come in handy because you're going to find this form and the subpoena ad testificandum on the same Google search. So again, go to google.com. You're going to look up New Jersey Superior Court subpoena form. The first result that should pop up in your web browser is a subpoena duces tecum. The second result is a subpoena ad testificandum. So looking at the subpoena duces tecum, so a subpoena can be issued by the clerk of the court, by an attorney, or by a party. It shall include the name of the court, the title of the action, and specify what is being requested, including a time and place for testimony, or for a duces tecum, it is customary to specify that the documents can be sent in lieu of an actual appearance. So now if we look at the actual form, you will see that just like the ad testificandum subpoena, it does request where this person is going to meet you and what they have to bring with them. But as I said, it's customary when you fill out this form, let the parties know that, hey, you don't actually have to show up. All I need is XYZ document. They can then send that to you in lieu of the appearance. I will tell you that is why a lot of people prefer the subpoena duces tecum as far as being served, because if you are served with this subpoena, you can send the documents. You don't have to actually worry about an appearance. And if, let's say it was for a deposition where you had to show up or provide the documents, if you're the one providing and actually serving the subpoena, you don't have to worry about recording it or anything like that, getting a court reporter to do a deposition. They would just physically bring these documents to you or mail them, and you would be done. So the form is pretty self-explanatory. You would just put in there what you're looking for, be very specific as far as the items go, and then you can sign it. So on the form it says Michelle M. Smith, Clerk of the Superior Court. But by court rule, anybody who is a party to the action can file a subpoena. So what I would ask is that you just fill out the form, sign it on the bottom, and it is good to go. However, there is a fee. A subpoena can be served by anyone over 18 and should be served with the fee allowed by law, $2 per day, and an extra $2 for every 30 miles of travel if the witness doesn't live in the same county as the hearing. That goes for both the subpoena ad testificandum and the subpoena ducis tecum. A subpoena requiring attendance of a witness at a hearing can be served at any place within New Jersey. So that would be the ad testificandum. So if you need them at a hearing, you can serve that anywhere in New Jersey. You just have to provide them with that fee. When requesting someone appear to testify, you can also request that they produce books, papers, and documents. I wanted to mention that because let's say you're thinking I need them to testify at my trial, but I also need them to bring X, Y, and Z documents. You can do that in the subpoena ad testificandum, but you do have to, when you're using that subpoena, require that they appear somewhere and testify. If you're only looking for the documents, that's when you'd use the subpoena ducis tecum. Out-of-state subpoenas. So let's say you're looking for somebody that does not live in New Jersey. So 48 out of 50 states have signed the Uniform Interstate Deposition and Discovery Act, as it's better known in the subpoena world, the UIDDA. So all states but Missouri and Massachusetts at this time are part of the UIDDA. So the UIDDA provides simple procedures for courts in one state to issue subpoenas for out-of-state depositions. For litigation between two UIDDA compliant states, when seeking out-of-state discovery in a state court proceeding, a litigant must first obtain a subpoena from the state court where the case is venued, and we've just talked about that. You can actually print our forms online, fill them out yourselves, and sign them. And you would then have to submit and present that subpoena to the clerk in the county in which the discovery is sought. So let's say you want a discovery from somebody in Pennsylvania. You would fill out your subpoena here in New Jersey, just as you normally would. You would then have to take that, though, and present it in the local county court out in Pennsylvania, and then they would take over and get you a subpoena that could be served within the state of Pennsylvania. So, and that's just a little bit of information. I made it sound very easy there. It is going to be a little more complicated, but it's a great start. I'd be remiss, I should say, if I didn't talk about motions to quash. So we talked about how to file the subpoenas and where to find those documents. What about a motion to quash? So if you are served a subpoena, you might say, hey, I can't comply with that. Let's say you have a business and somebody says, here's a subpoena ducis tecum. I want every business record and every sale from 1981 to today. That's 42 years, I think, 42 years of records. You'd say, that's too much, I can't do that. You have the right in New Jersey under Rule 1:9-2 to file a motion to quash, which says to the court, and I'm going to read you the rule, the court on motion made promptly may quash or modify the subpoena or notice if compliance would be unreasonable or oppressive. So you have the right to file that motion to say, hey, that's too much, I can't comply with that. The judge would then have a hearing to determine what the request is, what the relevance of those documents are, and then to decide if it is too much or if it is reasonable. It's tailored to what they're looking for, and you have to comply. The good news, if you file a motion to quash, you don't have to actually answer that subpoena while the decision is pending, so you will find out if the court says you don't have to do that before you actually go through the process. So thank you for watching this short video, but that was a little bit into subpoenas, and I hope you found it helpful.